One of the most frequently asked questions from clients is whether they will be able to keep their home. And my response to them is generally the answer is yes. And it's an urban myth that when you file for a bankruptcy, you automatically have to give up your assets. And that's simply not true. The Chapter 7 trustee is only interested in selling assets to generate money for the creditors. If the trustee cannot sell the asset and make money for the creditors, then he or she will not attempt to sell it. So, do you have equity in your house is the first consideration. If you have less than 10% equity in your house, as a rule of thumb, the bankruptcy trustee will not administer the house. And that's simply because when they pay the real estate agent and pay their own fees and pay the attorney's fees associated with the closing, there's not enough value in the property to generate any revenue for the unsecured creditors. Also, in Virginia, many married couples have their real estate titled as tenants by the entireties with common law right of survivorship. If you have your property titled in that manner, only your joint creditors can dip into the equity in the house. So a title search is always a significant consideration when a house is involved. Furthermore, Virginia law gives you an exemption, a protection from your creditors. It's like a shield. And that protection is $5,000 for each householder, plus $500 for each dependent child. And if you're over 65, the exemption is $10,000 per householder. Generally speaking, when you calculate the equity in the house, determine whether it's tenants by the entireties, and then look at the exemptions, generally the debtor is able to keep their house. There are some occasions where it is not possible to file for Chapter 7, and I actively, that's why you hire me. That's what I'm there to determine if you can keep your house. Now, even if you have some equity in your house, and even if you don't have all the exemptions to protect the equity in your house, you can always file for a Chapter 13 bankruptcy. And in a Chapter 13 bankruptcy, you're not giving your house away to the bankruptcy estate. And that's a little bit confusing. While you're in a Chapter 13 bankruptcy, the title is vested in your name, and you can at any point dismiss your Chapter 13 bankruptcy filing. So again, in a Chapter 7, you have all these considerations, and then in a Chapter 13, you can keep your house because in that case, you're making payments to your creditors instead of trying to sell your house.